Welcome to today's webinar on the Statute of Limitations. My name is Matthew Judd. I'm the Director of the Records Management Department here at Utah Retirement Systems, and I will be your presenter today. In 2016, the legislature added specific statutory language to Title 49, placing limitations on actionable claims. This change set a statute of limitations at 4 years for defined benefit claims effective May 10th, 2016. The impacts of a statute of limitations required a paradigm shift in the thinking of URS staff and may have a similar impact on your organization. It requires everyone to review their policies and procedures relating to retirement benefits and assess any changes that may be needed to better align with the principles behind a statute of limitations. So what are the principles behind a statute of limitations? Why do we have one? What is the purpose? The purpose of a statute of limitations is to promote repose. A statute of limitations is intended to reduce uncertainty about the future and to avoid disrupting settled expectations. For employers, the uncertainty has been receiving a bill for contributions and interest for a reporting error that occurred years ago. So the limitations help to reduce the cost due to the untimely claim. For employees, the disruption was coming in to retire thinking that they had enough service, only to be informed that a period of service reported years ago was not eligible. So the limitations here are intended to create peace of mind. It's a balancing act between the parties on both sides of the claim. So we have a statute of limitations set at 4 years for the defined benefit claim, but other areas may have different limitations. For example, most defined contribution claims are limited to 12 months, and some insurance claims are limited to 6 months, and there may be others. When does the clock start ticking? Typically, it should start at the point of discovery. More importantly, when it reasonably should have been discovered. So what impact did the statute of limitations have on URS policies and procedures? URS will now assume that the statute of limitations will be applied. Since we assume the employer will use the statute of limitations as an actionable defense, URS will no longer pursue action on claims made by employees for service corrections outside the 4-year statute. To balance between the statute of limitations and our fiduciary responsibility for sound funding, URS will no longer send ineligible contribution billings to bring ineligible reporting up to eligibility, but instead will prorate the service granted based upon the contributions paid. The fact that URS will not take direct action outside the statute of limitations does not mean that corrections cannot be made. Employees seeking a claim outside the statutory limits will be provided with a form to allow them to approach the employer directly to seek their permission to address the claim. Similarly, employers seeking a claim outside the statutory limits also have a form that they can present to the employee for permission to address the claim. An important part of these forms are the boxes that must be completed to identify the intent to make payment if needed. Calculating and billing for these adjustments is very time-consuming and costly for URS. Before we spend the time and the energy on that activity, we would like to know if payment will be made. For this, it is recommended that each employer determine in policy the action they will take in these matters, instead of taking a case-by-case approach, which may lead to discriminatory practices. The biggest concern for URS staff has been for the employees who may not know about the potential claims. Over and over, we have been reminded by our legal counsel that everyone is responsible to know their rights under the law. Certainly, employers care just as much, and we can work together to ensure that employees understand their benefit rights. So just remind your employees of the importance to know their benefits and to ask questions. Have them give us a call. Most importantly, they should review every statement carefully. Employers should provide employees with clear and complete benefit listings and conduct timely reviews of eligibility and status changes. If a status changes, be sure that the employee understands any impact made to their retirement coverage. Employers, do not think that this is a free pass. Your policies and procedures must be in place and followed to ensure that there is no reason available to toll the statute of limitations. The statutory defense can be lost if it can be proven that there was fraud or intentional concealment. So, to summarize, generally we're dealing with 4 years to make a claim on defined benefit service and 12 months for defined contribution corrections. Outside that period, the employee or employer will need to seek redress with the other party. There is a tolling provision that would allow claims outside the statutory provision in cases of fraud or concealment. I hope that this webinar has answered many of your questions, and if you have additional questions, please give us a call and let us respond to those. Thank you.